Good morning, everyone. This is Chris Vogt. I am very excited to be with you today because we have got two excellent guests. We're going to be talking about the differences between commercial forms brought to you by a commercial forms provider and commercial forms brought to you by a residential association of realtors. So the various state associations of realtors across the United States offer commercial forms as part of their residential forms package. And then there's also commercial forms providers, and that's what we're talking about today. We are going to have a lot of fun. And let me introduce our guest and Bryan Mashian and Neil Kalin. Please join us there. It's time to turn the cameras on and show the world who we are. So I am very pleased to have these guys with you. And the reason is because way back when I started in commercial real estate, it was back in 2019 that I actually launched into commercial real estate as an agent after over 40 years of being involved in commercial real estate as a owner operator and as someone who grew up in a family that bought, leased, and sold commercial real estate as part of our family business. And I did property management for properties in the Silicon Valley for the company I was working for, did all the contract negotiation and everything. So when I launched into commercial real estate as an agent, one of the first things I wanted to do is really get myself educated on forms and how things work. And Bryan and Neil actually did a webinar in March of 2019 that I was there live, just keyed in to the webinar. And that's where I really got my first look and learned about how forms are different depending on who produces them. Now, because we have agents all over the United States, we have generically called this the commercial versus residential form showdown. But specifically, we're going to be talking about forms in California, and maybe Bryan's going to talk a little bit about forms outside California because AIR does forms outside California. So let's start with Bryan. Bryan, if you could please introduce yourself, give us just a little bit about your history and how you got involved in real estate forms as an attorney, specifically, that would be very helpful.
Sure. Thank you for inviting me to speak today. So I've been practicing commercial real estate law, and this is my 42nd year. And I specialize in transactional work, and I was with a firm called Buckhalter Niemer, where I head of the department, the real estate department, and in that firm we represented the AIR CRE in revamping their contracts. And then I set up my own firm in 2006, where I've been practicing since on my own, and I'm pretty much doing the same thing I've been doing all my career, which is doing real estate deals and real estate disputes. And 10, 15 years ago, AIR reached out to me and said, we'd like you to head the contracts committee. And in that role, I am in charge of updating the contracts to adapt to new legal requirements that have changed, passed from time to time. And also, I staff a hotline for the AIR contract users and members where they call with general questions about how do contracts work, et cetera. And that gives me a real vantage point to see how do these contracts really play out in every day when people try to use them? What problems do they encounter? And that gives me a real good sense of what needs to be changed, what's working and what's not working. And I also do a lot of speaking for Bar Association. Actually, Neil and I, one of the first things we did was for the State Bars retreat. We did the same seminar for them. So we both do a fair amount of speaking.
Excellent. Neil, CAR, California Association of Realtors, you've been on staff with them for a hot minute, right?
Yeah, if you consider almost 40 years a hot minute, yes, I've been here a long time. I started on the CAR legal hotline when I was a fresh attorney, and did that for several years. And then my boss at the time, who was the legal advisor to our forums committee, asked for some assistance, and I volunteered. and I've been involved with forms probably for 30 years, 30 years now at CAR. I really do not do very much, if any, legal hotline calls anymore. Most of my time is taken up working on CAR forms. There is approximately 250 forms in the CAR library, most residential. Obviously, today we're going to be talking about commercial forms. We have some business forms. We have a lot of landlord, tenant, property management forms, and we have a lot of back office forms. So, huge library. There is a committee which advises CAR on which forms to revise and whether to create new forms, and every once in a while, whether to remove a form from our library. And so I'm the senior advisor to that committee, legal advisor to that committee, and I now have the wonderful opportunity of sharing that with two of my colleagues. I was just sharing it with one of my colleagues, and we realized there's just too much for one person to do with that vast library. And we change our forms, as I say, twice a year, every June and every December. We don't change all 250 forms, but we do go through a forms release twice a year. And one last thing I'll mention before we move on, which is CAR makes a very concerted effort to make it easy for our members to use our forms regardless of their practice area. So if we change our residential purchase agreement, we will simultaneously change our commercial agreements so that when our members use our forms, they know what they are going to be getting, regardless of which practice area they are in.
All right. I shared the screen, which has our contact information stuff on it. So anyone who wants to, take a screenshot and get in touch with any of us, and we'll show more information at the end of the presentation on how to get in touch with both Bryan and Neil. Today's roadmap, we just did our introductions here a little bit, and then we're going to talk about perspectives and philosophies. That's a huge part of how residential and commercial agents view contracts. Then we're going to talk about the contract creation process a little bit, and then we're going to get into the presentation that Neil and Bryan have given many times for bar associations and other groups. So that's where we're headed today. Neil, just starting out, I think probably most agents, they start in residential and some of them migrate into commercial. And the whole perspective that I see with residential forms, it's really consumer oriented. What do you think about that?
Well, I think for the most part that's true. CAR thinks of itself as an organization not just for real estate licensees, but also somebody who's looking after the consumer in a real estate transaction. And there's really no other organization that has the interests of the consumer in mind. So we we craft our forms to try to make them as easy to read and use as possible. So that's one thing to do. And we also need to take into consideration who's using our forms. So our members represent buyers and sellers. We do not want to have a form that is a one-sided form because that's going to make things difficult for half our membership at any particular point in time and during any particular transaction. So we try to be as balanced as possible. We try to protect the interests of the consumer, and we try to protect the interest, of course, of our member realtors at the same time.
All right, Bryan. So commercial forms, they seem to have a little bit of different philosophical structure to them and who they're representing. Do you want to talk about that a little bit, please?
Yeah, I think our philosophy is AIR CRE is a broker organization. The organization started in the 60s with the idea of preparing contracts that people can do deals without necessarily involving lawyers and have the brokers, title, and escrow companies handle the transaction. Over the years, the contracts have become well received and well accepted in the industry as being balanced contracts. Now, if I had to, for the purchase and sale agreement, select which party do they favor, I think, first of all, we put in as many protections as we can for the brokers, and we don't apologize for it because it is a contract that they publish and they pay for to be prepared. And I think second, I would say it balances the interests of the buyer and the seller by favoring the buyer more in giving opportunities and disclosures so that the party who's most likely to sue in a purchase and sale transaction is a buyer either during or most likely after the close of escrow. They discover something that they were not expecting. So the philosophy is to protect the buyer by giving the buyer ample opportunity to do the inspection and not be forced to buying the property or forfeiting money. And we have 70 contracts, 70 plus contracts in our library. They've been vetted out through many, many years, many cases. And the philosophy is really to balance the interests of both sides. It's, while I say it's buyer protective, it's really meant to be, how do we get the deal done quickly, cheaply, without necessarily involving lawyers? And that's the overall approach. And I think it's been successful. I will say that our contracts are used, and I will use them in my practice as a lawyer. I use them as a buyer or as a seller. We also have an extensive library of commercial leases. So I'm happy to pull any one of the contracts off our library and use it. And I don't believe it's overly one-sided. So that's the challenge in striking a balance between the competing interests of the two parties. And that's why when we call it a standard contract, it's been time tested and vetted, where people have accepted, yeah, this is a fair balance. And that doesn't mean that it's straight down the middle of the fairway. Rather, it always protects somebody a little bit more than the other because it's appropriate for the transaction.
Okay.
Chris, if you don't mind, can I
Yeah.
take another 30 seconds here? When I started working on forms, almost every major brokerage company used their own form for a purchase and sale. And it really created havoc throughout the industry. If you were writing an offer and you submitted your company's form to the other side, and maybe you've done 50 deals with the other company, you could have changed your form the day before and they would have had no idea. And somebody would have to look through every line and every word to find out what the differences are. Now, today's CAR, because of what we've done working with our committee and working with our lawyers in creating, really much like Bryan was talking about, a fair and balanced form that recognizes the interests of all parties and the real estate licensees, we're now the predominant provider of forms in the industry. We're not the only ones in California, but we're the predominant ones. And the reason for that is our members have confidence and they don't feel the need for every brokerage to have their own purchase and sale agreement. It's much easier on the transaction if people are using a form that they are all familiar with.
No, that's really good. Bryan, you mentioned that you build in some broker protections. Can you give us an example or two of how the AIR CRE forms protect the brokers?
That's part of the presentation that we're going to review. I'm happy to jump to it now if you want.
Oh, just give us a preview and then we'll go into more depth as we get into the
Sure.
presentation.
So for example, the agreement says that if one party breaches the contract, they owe the broker the commission that the broker would have earned had the deal closed. That's one thing. So that you work hard, you bring the parties together, one party breaks the contract, you as the broker are going to get compensated. Our contracts, for example, second item, states exactly how much is each broker getting. Now, some brokers may not be comfortable with disclosing and divulging to the parties the exact amount of their commission, but our contract discloses it, has it upfront in there. Nobody can claim that they didn't know how much the brokers were getting, and that becomes part of the agreement and the escrow instructions that the parties sign. There is a third provision where we limit, in case of a lawsuit against the broker, the amount of the damages that a broker is responsible for. We put a cap on it. We also put a shortened statute of limitation, meaning we reduce the legal time limit that somebody has to sue a broker. So these are some of the main protections, and I'll give you the exact references to them in the contract once we get there.
Excellent. Those are really important. And one of the things I really like about the AIR forms, as opposed to the CAR forms, is that those broker protections. So Neil, do you have any broker protections built into the CAR forms?
Yeah, so
along
I'll
the
mention
same lines?
three. So, unlike the AIR form, we do not have a written dollar percentage amount of the broker compensation. They need to supply their own agreement to escrow, whether it's on the buyer side or it's on the seller side. But brokers are made a party to the escrow, but solely for the purpose of receiving compensation. And under that escrow provision, the parties are not permitted to change the broker compensation that has been agreed to in that either a listing agreement or a buyer representation agreement without the broker's consent. And one third item that I think is very helpful to brokers is we have an arbitration and a mediation clause. And a broker has a right to opt in, but a broker cannot be forced into arbitration or mediation by the principals under the express language of those two clauses.
Let's talk a little bit about the process of how forms are created and modified over time. I mean, CAR, they come out on every 6 months, right, of updating forms. And AIR, how often are forms updated with you guys?
Our contracts are modified as needed. Our contracts committee meets regularly. We have input from our users that I collect. I get a lot of emails, phone calls. We do also educational seminars for our users. We have 13,000 users, and we do seminars, in-person seminars, and they're also available online. People will give suggestions, and we consider them. And when we think it's appropriate, obviously we incorporate those from time to time. We don't necessarily have predetermined dates by which we republish the contracts, revise and republish the contracts. We obviously, if there's a change in the law, we respond to that and make the change that's required in a timely fashion. But the contracts committee is myself. I'm the head of the contracts committee, and there's seven brokers on the contracts committee. And it's really, the process is a very intensive discussion and analysis of all the different perspectives. The buyer, the seller, the broker, the landlord, the tenant, escrow, title. So all of those things are vetted out at the committee to make sure that what we're doing has repercussions throughout the transaction, and we consider all of those before we make a change.
From what I've heard, and I don't actually know, I've just heard that the committee at CAR is mainly residential agents, and that they have a huge input in the wording actually that goes into the contracts.
So the committee is 21 members, and I mentioned earlier there's 3 lawyers that provide legal advice to the committee. The members, the 21, there are some agents, there are mostly brokers and risk managers, and there's also a few of our members who are lawyers who sit on the committee.
Attorneys who are also practicing real estate as agents, or
In some cases, there are attorneys who are members of CAR and very active in CAR. And then when we have a committee, so I say we've got an extensive library. The committee meets 3 times a year in person at CAR regular business meetings, and they meet every single month to go over comments. We receive comments on the website, CAR forms at car.org. We get hundreds of comments a year. The committee reviews every single comment and makes a decision, yes, no, yes, but maybe with a modification, or yes, this is a good idea, but we just recently changed our form, so let's put it on hold for a year or two until the next time that form comes up for revision.
so I'm assuming that legislation obviously is going to impact forms, and so that's a priority to make sure that they're legislatively up to date. Um, but when you get suggestions from agents, how is it? What is your thought process, or I mean, the forms have been around for quite a while, so there's got to be some impetus for changing a form. What do you find is usually that impetus?
Yeah, the impetus is whether there's a bit change in industry practice, that could be one. Whether there is certainly just like AIR, if there's a legal change, we will make that change immediately, even if it's not on our June and December release date, if we need to. A lot of legislation that CAR proposes usually has a delayed effective date to give us time to get the changes into our forms when the changes as a result of something that CAR has proposed at the state legislature. But for risk management issues, we look at, is there a significant change that is going to make a difference in the industry if we do it right now? Or if it merely is an improvement, can that improvement wait? Is it so important to the industry that it needs to be, that the suggestion needs to be implemented right away? So that those are always in the back of the minds of our committee members. We have a general rule that all of our forms, our 250 plus forms, nothing will be in our library that has not been reviewed in the last 4 years. So you will not find a revision or review date any older than 4 years in all of our forms. So that means at the very least, we're going to look at a form once every 4 years, make sure that it's current, it's up to date, it represents industry practice. And quite often for forms that get used a lot, like the purchase agreement and many of the disclosures, you will see changes more often than that.
Okay. Now, commercial forms in particular, Neil, there's so few, what I think it's 5% according to the National Association of Realtors of NAR members that practice commercial real estate on a semi-regular basis or full time. So what what's the composition of your committee that is actually well versed in commercial?
Okay. So certainly the overwhelming number of CAR members practice residential real estate. I have not seen any statistics on the percentage that work in commercial real estate matters, but just from my anecdotal experience, 5% would be way too low at the California level. Especially when you look at some outlying areas outside of the major cities where real estate agents who do residential practice, they'll represent somebody who has a strip mall or who is in business, who wants to rent a property or lease a property in a primarily a commercial fashion. And that just is out of necessity. That's what needs to be done for the areas where there is not so much congestion of residential properties. So it's got to be way higher than 5%, but do I have an exact number? I do not.
But how about like the committee itself, your 21
Oh,
members?
okay.
Talk
So
about that and,
yeah.
their experience in commercial because
Oh,
commercials, there's only a few forms compared to the number of residential forms.
well, that's true. And I would say out of the 21 members of our committee, there's always at least two or three who have commercial experience. And what CAR does is when we are going to revise a form, we can create, we call it a study group. It's essentially a subcommittee. And we go outside of the primary committee members and we bring in people, whether they're members of CAR or not, who have experience in that field. And the last time we did major substantive changes to our commercial forms that were not just conforming to residential changes, that's exactly what we did. We created our study group or our subcommittee. We brought in people who do this all the time. We did the same thing a few years ago when we updated all of our business forms. We brought in people that may have had no relationship with CAR at all, but we knew they were practicing and they were selling businesses. The committee chair was a CIR member who sold businesses as well. But we bring in experts, and then the draft itself will be presented to the full committee. Like I say, usually two or three out of the 20 are commercial brokers.
And I actually had the privilege of serving on the California Association of Business Brokers Forms Committee for about 18 months when I was doing business brokerage. And that was a very interesting process. And we had business brokerage attorneys, some attorneys who were also business brokers, and then some just business brokers on that committee. It was a very fascinating process. Bryan, the AIR CRE forms are also offered to CAR members. Is there any difference between the forms that are offered through zip forms to CAR members versus the ones that are available to the AIR CRE members?
Not that I'm aware of. It's the same library that's available to you if you subscribe directly through the AIR. I I want to mention that the AIR's library is now available in all 50 states, and they have been AIR went through and hired a local lawyer in each one of those states to customize and conform the contracts to the local custom and practice and the local legal requirements. Surprisingly, there were not that many changes in the contracts when they were adopted for each state. So one nice thing is that if you use our contracts here in California, you can use them throughout the country. I do not know, and the reason I brought it up is whether if you subscribe through CAR, you get access to all 50 states. I think you do get access to all 50 states if you do it through AIR. So I don't know that.
Yeah, I think it's limited. I don't subscribe through CAR. I subscribe directly with AIR CRE. Neil, do you know the answer to that?
So I believe the AIR forms that are available through the CAR platform, which is zip form, and then we
Mhm.
have some partners as well, but through zip form. I believe that is the AIR California Library.
I think that's correct.
Yeah. Okay. So we're going to take a quick side trip here because this broadcast is brought to you by uh, the Realtors Commercial Alliance of California, which I'm the Secretary Treasurer this year and the CEO. And next year I will be the president. So I'm president-elect right now. And our mission is, as the only commercial association of realtors in the state of California, we empower our members to thrive in commercial real estate through education, networking, and fostering collaboration among commercial residential real estate professionals and business brokers. And we have a number of benefits that we offer our members, including education, the opportunity to network and pitch projects, social events, and a member hotline. And we have a couple events that are coming up. So if you're listening to this on a replay, these events may be coming. If not, please sign up at our website to join our free email list at rcaoc.org. And coming up in September, we have two great events for you. The first one is our Summer of AI series, which we've been having a lot of fun exploring different topics of artificial intelligence and how it relates to commercial real estate brokerage. And we're going to be doing the art of seducing AI, romancing AI to recommend you, which is basically how to get the artificial intelligence platforms when you ask questions or when your clients are asking questions, that it actually brings you into the conversation and shares who you are so that they can connect with you, which is a big thing that's changing in the whole search engine space. The next thing that we're going to be doing is we're going to be talking about using trust creatively to hold commercial real estate. So those are two exciting things that we have coming up in September for you. Oh, and in our live stream library, if you're joining us on YouTube, then click that link and you can watch. We just recently did last month the mid 2026 commercial real estate update with Dr. Lawrence Yoon, the NAR chief economist. It's an excellent interview and has a lot of very current information about what's happening in the economy related to commercial real estate, especially as this is an election year and there's a lot of legislative things going on. And also in the library is the Trust Crisis in Commercial Real Estate, Dealer Deepfake. And Eric O'Neill joined us for a really, really fascinating conversation. He is actually a spy hunter, and he brought down the largest trader ever from within the FBI and brought him to justice. And deferredtax.com is the sponsor of the Realtors Commercial Alliance. So we invite you, if you have tax questions, to visit the website and check out what they offer, deferredtax.com. All right, guys, this is the program that you've put together for bar associations. And I know that we may not be able to get through all of this, but the nice thing about replays and streaming on YouTube is people can come back and watch this again. So I'm going to let you guys take it away, and I may interrupt every once in a while with some conversations. How's that sound?
Great. Why don't you share your screen so we can all be looking at
Oh,
the
I
slides.
didn't hit share. So I went through and I shared my slides and I wasn't sharing. Oh, that happens, right?
No problem.
Okay,
So,
well, let's just back up so people can see real quick. All right, mission statement, membership benefits, calendar, and there we go. All right, we're back to you.
okay. So you can see we've got about, I think, 12 items. I'm not sure if we'll be able to get through all of them, but why don't we just start with the first one, real short, and go to the next slide, I believe, probably.
Yeah, just let me know when you want to advance the
Okay.
slides.
And just real briefly, I want to talk about format. So our commercial agreement conforms to our residential agreement. And oh my God, I think it's probably like 8 years ago now that CAR went to basically an all text format to a grid format. And you can see that I just did a screenshot of the first page and just part of the grid format. It has been amazing since we've gone to that format in our purchase agreement. CR members have said, we want to see that format in other agreements as well. So after we did the purchase agreement, our members said, do that to the listing agreement, do that to your buyer representation agreement. We're doing a change to an addendum, the addendum where the buyer comes in and says, I need a contingency for the sale of my property. We're doing that there as well. The in the purchase agreement, the grid goes on for 2.5 pages, and it's just a way to kind of get a quick encapsulation of what the most significant terms are all about. All fill-in fields for the CAR forms are in the grid itself, and then you've got explanations as to what those paragraphs are all about. On the grid, you can see that the second column of that grid shows the reference paragraph that one would look at to get an additional explanation. The only exceptions to that is for the liquidated damages and arbitration clause, that the law says those clauses themselves have to be separately initialed. So the first few pages have the grid, all the fill-in fields, and then the last couple of pages is where you find liquidated damages, arbitration, and of course the buyer and seller signatures. So it has been an amazingly successful change in the format and approach to the CAR purchase agreement and now other forms as well.
Okay, we advanced the screen for you.
Okay. And Brian, why don't you talk a little bit about this?
Sure. Okay. One of the questions that has come up over the years is, are these really purchase and sale agreements? Are they options? What are these contracts that both the CAR and AIR publish? And both of us were affected by California Supreme Court decision of the 2010 Steiner versus Sexton. I'll just give you a quick background because I think it's helpful to understand how the contracts work and why they were changed. In this case, in Steiner versus Sexton, the buyer went under contract to buy 10 acres out of a 12-acre parcel. The buyer was supposed to do a lot split at buyer's expense, and the buyer could cancel the contract in his sole absolute discretion at any time. The buyer spent about 60 grand, completed most of the work needed for the lot split, and then seller said, no, I'm not selling this property to you anymore because the contract that we signed is actually an option. It's not a purchase and sale agreement because you can cancel at any time for any or no reason. And that's an option in your favor. You didn't give me any option money, which is what the law requires you to have a valid option if it's not a purchase and sale agreement. If you go to the next slide, please. The California Supreme Court said, yeah, this is contract is called a purchase contract, but that doesn't really determine the legal effect of the agreement. The court looked at the substance of it and said, yeah, this was really an option agreement because only the seller was bound and the buyer could back out at any time. And the buyer's initial promise to get the lot split done really was not enough to make it a consideration that would make it a binding agreement. But And that, there was an argument that there's an implied covenant of good faith and fair dealing by law. Doesn't that suffice? And the court said the actual language of the contract uh, overrode that implied covenant. And the court said in this situation, the option was supported by consideration. And if you go to the next slide, please, Chris, the court said, even though the contract as at the start was maybe at an unenforceable illusory option, when the buyer substantially performed what the bargain for consideration was, that made it a binding contract. In other words, when the buyer spent money and completed about 75 to 90% of the lot split work that was what the parties bargained for, that created the consideration that made it a legally valid binding contract. And the court said, no, that this contract, which may have been unenforceable at the beginning, became enforceable by virtue of the buyer performing the bargain for consideration, and the buyer prevailed in that case. So the result of that is, I think if you go to the next slide, please. Most contracts, our contract, and I think the CAR contract gives what we call a free look to the buyer. You make an offer. Once the offer is accepted, you open escrow, buyer goes through his due diligence. If the buyer's not happy, the buyer can cancel, get his money back, and go home, and no harm, no foul. So since this could be considered to be an option, after that Steiner versus Sexton decision, we added section 4.4 to all our purchase and sale agreements, which basically says the escrow company is going to give $100 of the buyer's earnest money deposit to the seller in return for the seller entering into the agreement with the buyer, which gives the buyer a free look. And the $100 is not refundable to the buyer, but it's payable to the seller, even if the buyer chooses not to buy this property. So this was our basically provision to create an insurance policy that the contract will actually be enforceable, even though the buyer has a quote unquote free look. And I'm going to let Neil talk about the CAR contract.
Right. So we took a different approach because, first of all, we did not want any of our members or their clients to believe that the contract was anything other than a contract. We don't want our contract to be interpreted as an option. We want it to be interpreted as a contract. We do not really have a free look provision, and you could see in paragraph 17 and paragraphs 8A that the buyer who has a contingency built into the contract as an investigation contingency, a loan contingency, they might be waived, but we're just dealing with the basic essence or basic elements of the contract. There are contingencies, but we are concerned that if the buyer had the right to get out in the buyer's absolute and sole discretion, as was the language in the Steiner versus Sexton case, that our contract might be interpreted as being an option. We don't want that to happen. So we expressly say that any removal of contingencies must be exercised in good faith. Now, might there be an issue as to whether a buyer is acting in good faith or not acting in good faith? Yes, but it is no longer absolute and sole discretion on the buyer's part. The buyer can use a subjective good faith judgment and get out based upon their investigation or inability to get a loan, for example, as you see there in 8A1. So that was our approach. We said, we don't really have a free look. It's not that difficult for a buyer to get out, but sometimes you might have a situation where it's pretty apparent where a buyer is acting in bad faith. And if a buyer is acting in bad faith, that would be a breach.
So one of the other differences between the AIR approach and the CAR approach may at first be, it may seem to be a different, but I think at the end of it, maybe they're not hugely different. Our contracts, the AIR contracts, have what's called passive approval, meaning that the contract is set up for the buyer to have a due diligence period, and once the time comes for the buyer to approve or disapprove of a contingency, if the buyer doesn't actively disapprove, then the buyer is deemed to have approved. So that's what we call passive approval process. And This is very important for those who are used to working for both, working with both the CAR and the AIR library of contracts. Keep that difference in mind. I had a call from a broker who was used to working with the CAR contract. She had repeatedly told her client, "Don't worry, you have not removed contingencies. You still can get your money back." And she called me when I told her the fact that we have passive approval versus the CAR regime of contracts. She was very unhappy. And you want to make sure that you understand the contracts when you start to use them, before you start to use them, and especially if you're going to advise the clients about how do they actually operate. It's very important that you fully understand that in the AIR regime, the library, the passive approval is there in section 9.1. And one of the things that I'm going to tell you guys not to do is don't mix and match. Don't use a document from the CAR library when your base contract is an AIR contract, or vice versa. You got to decide which side of the road you're driving. Are you driving on the left side or the right side? And don't keep going back and forth. Neil?
So one of the things that I found as I mentor residential agents in commercial real estate is it takes them a hot minute to really get the idea, what is the difference between active and passive approval. Neil, maybe you can talk a little bit about that too.
Yeah, absolutely. And first of all, I echo Bryan's sentiment, which is do not mix and match your forms. Decide which library you're going to use, stick with that library throughout your transaction. If one library does not have a form that you think would be beneficial, then you're really going to want to have outside counsel review that form that you want to submit that was not a part of the original library that you started with. And maybe you can go to our next slide and it'll help explain the the active removal of contingency process that CAR uses. And what CAR says is that a contingency must be removed in writing, otherwise it stays in effect. And so you see the paragraph there down at the bottom of the slide, the continuation of contingency, even after the end of the time specified, okay? Buyer retains the right to remove contingencies or cancel the agreement. So the mere passage of time does not determine whether the contract goes forward or whether the contract terminates. Okay. It means nothing. The only thing that has meaning in the CAR contract in terms of a contingency removal is somebody needs to do something in writing. So the buyer can remove contingencies in writing, or the seller can give a buyer a notice that says, you have not removed your contingencies. You need to do so, or I will have the right to cancel as a seller, but the cancellation will not happen automatically. The seller will need to follow that up with a writing and with a cancellation. And that's on the next slide that shows that. And that's the notice to perform concept that CAR has adopted into its forms. When I started working on forms, as I say, 30 years ago, CAR basically had the passive removal of contingency method. And then we discovered that there was different practices in the state. Some parts of the state were using passive, some parts of the state were using active. And as our members kept discussing this issue, we realized that passive was creating difficulties in transactions because parties would have continued negotiations and may have slipped by the time period for something to be done, thinking that as long as they were actively negotiating, that time would just automatically extend. Well, that's not the case with the passive removal. When the time lapses, that determines what happens with your contingency or maybe another contractual action. And so because of that, and also because in residential transactions, there tend not to be lawyers involved in the transaction. So there may not be somebody overlooking the transaction from the outside to try to prevent those accidents from occurring, CAR gradually shifted over to the active removal of contingency and has had that for over 20 years now.
Can I add something here, please? And that is, while I say the AIR has passive approval, there's slides that are coming up in the presentation, which I'll point out. The buyer's time for approving of a contingency in many instances does not even begin to run till the seller provides, for example, a property information sheet, the seller's mandatory disclosure statement, a title report, leases, estoppel certificates. So quite a few of the contingencies do not even begin to run till the seller does something. So I just want to clarify that it's not the situation where all of a sudden the buyer wakes up and the contingencies are over. It doesn't happen that way. We have different contingency dates for each one versus I think the CAR has a 17-day for all contingencies, but even Neil, correct me if I'm wrong, even if it's that 17-day period is extended, if a seller doesn't timely provide a document, that's subject to the buyer's approval, right?
The default is 17 days. If the seller does not insist upon the buyer taking action by the end of that time, then you have a continuation. Nothing happens either favoring the buyer or favoring the seller after that default period of time.
Right. Okay, so now let's talk about what I phrase as the retrade process. In every deal, once the buyer goes through his due diligence, the buyer will come back with its results and ask for something, either price reduction, price credit, seller to do some repair, ask for more time, something. And the inspection and negotiation process of the AIR contracts is governed by Section 9.3. And basically, if the buyer disapproves or conditionally approves of something, then the buyer has the choice to not ask for anything, meaning not ask for a price reduction or price credit, not ask the seller to do any repair, not ask for more time. And in that situation, if there's no buyer request, the deal's over because at that point, the buyer's just saying, hey, I'm disapproving. So that means the deal's over. Now, if the buyer does ask for something, if you go to the next slide, please, Chris, then the seller has 10 days to respond to the buyer's request, whether it's for price reduction, price credit, more time, etc. If the seller accepts the buyer's request, that automatically amends the contract. You don't need to go to escrow and say, can you drop an amendment to the escrow instructions that says you get 10 more days? We did that on purpose because a lot of times things happen in between the parties reaching an agreement and then going to sign the escrow instruction. So if you use, in our library, we publish a buyer's notice of disapproval, a seller's response, and a buyer's reply templates that you can use those to go through this process. If you use that, it automatically, if the seller accepts the buyer's request, that automatically amends the contract. Now, if the seller doesn't say anything, then the buyer has still 10 days after that to decide, okay, I don't want the deal anymore, I get my money back. Or if the seller did respond, accept the seller's response, or withdraw the buyer's request and stay in the saddle, stay in the deal, and keep going. So what's important to keep in mind is that if you go to the next slide, please, Chris.
Yeah, before we do, so let me just clarify. So if the seller doesn't respond, their silence is deemed a rejection at the end of 10 days.
That's
and
right.
then the buyer has 10 days after the expiration of those 10 days to make a decision, correct?
That's correct. And the reason we have this built in potentially another 20 days for the buyer to decide what to do, because if the seller can take up to 10 days, doesn't have to, could decide on day one, no, I'm not giving you a $50,000 price reduction for the roof. And then the buyer still has 10 days. So that buys the buyer more additional time. And we think that the brokers work hard to bring these two parties together, negotiate the terms, get into escrow, and we want to have enough cushion in the deal to let the brokers massage the deal and see if there's something to resurrect and keep going. So
yeah, we used to like to say in commercial real estate, a deal dies at least 3 times and has to be resurrected.
Right. So if you look at this chart, which I summarized section 9 of our contract, it basically tells you when does each contingency start and when does it end. And for example, in 9.1a, the seller is required to provide seller's mandatory disclosure statement and a property information sheet. The seller has 10 days to provide that, then buyer has 10 days to approve of that. The physical inspection in 9.1b doesn't even start till the buyer gets the property information sheet from the seller. So potentially, if the seller doesn't act properly and give the property information sheet to the buyer on day one, the buyer's physical inspection contingency is just continuing and getting longer and longer. Some of them, for example, the hazardous substance conditions report, the phase 1 environmental site assessment, that starts when the buyer receives the proper information sheet or the date of agreement, and that it continues for 30 days. So look at F, title, for example. The title review process, the title review due diligence or contingency period doesn't start till the buyer gets a titled commitment from the seller or escrow, underlying documents, and a scaled and dimensioned plot of the easements. So the seller is supposed to give that within 10 days, then the buyer has 10 days after he gets all those 3 items to review and approve of them. If you go to the next slide, please. Well, the ALTA survey contingency, buyer has 30 days after receives all those title product that I mentioned. With the leases and estoppel certificates, this is built into our contingency period. The seller has to, within 10 days, to provide the buyer with leases and estoppel certificates, and then buyer has 10 days to review and approve of them. Same thing with the owners association and other agreements. So you see that what we have, what I call is a floating contingency expiration date. And if you can go to the next slide, please, Chris. This is a summary of the inspection and negotiation process. So starting from the top, if buyer does not disapprove, that's deemed approved. That's the passive approval process. Then you go to if the buyer does disapprove but doesn't request anything, the contract terminates. If the buyer makes a request, the seller accepts, that modifies the contract. If the seller rejects or doesn't respond at all, then the buyer can withdraw the disapproved item or the buyer can cancel. So ultimately, the buyer's in the driver's seat, whether to buy or not, and whether to go forward with the transaction. I think now it's Neil.
Great, thank you. And so CAR has a different approach, and we're going to see that approach in just a minute from now. I started here, probably should have reversed the order of these slides. But during the investigation period, as I say, you're going to see in just a couple of slides, there is a default investigation period. It defaults to 17. If you're in a commercial transaction, you need more time, then you just change the default to something longer than 17. Our approach is by the end of that time, we want to know what's going on with the transaction. There's certainly a logic to the way AAR conducts their process. A back and forth and a back and forth. Definitely a logic to that. The CAR approach is just different. It says we have a certain period of time. We want to know what's going on at the end of that time. Is our transaction going forward, or is one of the parties going to cancel? During that investigation period, the buyer has a right to make requests of the seller, and the request could be for repairs. The request could be more in the case of residential than commercial, pest control work, or a credit, or a price reduction. And so then go to my next slide. Go to the next slide, please. Right. And then the seller has the ability to respond. Now, all of this needs to take place within, and I'm just going to use our default, the default 17-day period. All this needs to take place within that period. We don't care if it takes place on day 1. We don't care if it takes place on day 17. The longer the party waits, the more difficult it's going to be to enter into a transaction. But the seller can respond. The seller can respond on that same form that the buyer used to make requests. The seller could say, I agree to everything that you asked for, buyer. I agree to some of what you asked for. Maybe I agree to a price reduction instead of doing repairs, or a credit instead of doing repairs. The seller has the ability to respond. if the buyer agrees, or start off, if the seller agrees to everything the buyer wants, great, you have an agreement. The buyer has also automatically agreeing to remove their investigation contingency. If the seller then makes some alterations and the buyer agrees to that, then the buyer is also simultaneously agreeing to remove at least the investigation contingency. But the seller could say, buyer, as part of my alterations, I want you to agree to remove other contingencies as well. And let's go to our next slide. And again, here's, another portion of the grid in the purchase agreement. You can see sort of in the fourth column, the default time for everything is 17 days. But I want to remind everybody, first of all, you can always change the default, as I mentioned before. But if you look down to L5 and L6 and L7 and even L8, of course, it does not make any sense to tell a buyer you have a total of 17 days to make a decision if the seller doesn't provide you the documents or the HOA doesn't provide you the documents, for example, on time, because that could really reduce a buyer's ability to have time to think about what to do with something. So you see with some of these time frames, the time to make the decision in or out is not just flat based on 17 days, but 5 days after delivery, right? So normally a seller would have 7 days, and essentially a buyer would have, 10 days to figure out what they're going to do or negotiate with the seller during that 10-day period. But if the seller is late, we're telling a seller, you can't wait till day 16 to provide information to the buyer and expect the buyer to make their decision by day 17. At a minimum, the buyer is going to have 5 days to try to figure something out. And we got the next slide. And again, this is just what we talked about before, which is by the end of the time specified, something needs to happen, right? Either the buyer is going to remove their contingencies, or the seller is going to give a buyer a notice to take action, or the seller would have the right to cancel. And again, you see there in 17B4, if nothing happens, then nothing happens, right? There is no automatic decision. I mentioned there is a logic to the way the AIR form back and forth works, but there are some automatic decisions that happen depending on whether a buyer does something or does not do something. 17B4 in the CAR commercial purchase agreement says if nothing happens, that does not mean anything. Somebody needs to do something in writing.
So, Neil, why did you guys choose 17? Is like
Our,
two
our,
weeks plus a weekend or something?
so I wish there was some clear cut, vision that happened. Uh, at one point in time, CIR had different defaults for different contingencies. And our member said that's becoming unworkable to try to keep track of that. So one of the items that we could not vary was the inspection for lead-based paint and lead-based paint hazards. Under federal law, a buyer is given at least 10 days to evaluate the property after receiving the seller's lead-based paint disclosures. So since CIR had settled on 7 days was adequate for the seller to provide all of their disclosure to the buyer, and under this one provision pursuant to federal law, there's going to be at least a 10-day sort of waiting period. That takes us to 17 days. And I remember said, rather than have different default contingency periods for loan and investigation and title and insurance and whatever else there is, let's just stick with one. We know we cannot, by law, change that 10-day period for lead. So that takes us 7 and 17, and our members were comfortable with those two time frames as the default in the purchase agreement.
That's an interesting backstory.
Go to the next slide, please. So the AIR contract in section 8.5 reflects the Southern California custom for the allocation of closing costs between buyer and seller. As is the customary Southern California way of paying the closing costs. Escrow charges are split 50-50 between buyer and seller. Each party pays half. Seller pays the recording and the transfer taxes, and such as documentary transfer taxes, ULA, or the mansion tax. And the seller pays for the standard policy of title insurance for the buyer. And the buyer pays for the upgrade of the standard policy of title insurance to an ALTA policy. That's predetermined in our contract, and I think it's varied a little bit from state to state, but that's how it is in California. Neil?
Yeah, great. And so CAR, and Brian, I'm hypothesizing here that AIR started as a Southern California association or entity.
You're correct.
And
Yeah.
and that's probably where they adopted saying, well, this seems to be the practice in Southern California. And then form usage of AIR forms, AIR CRE forms spread beyond just the Southern California region. That element did not change. CAR has always been a statewide form, and practice is very different, not just from the brokerage industry and the escrow and title industry, but also in terms of how certain costs are treated depending on where you are in the state. So if we could go to the next slide, please, Chris. You could see that the CR, we just list out the most common expenses in the transaction, and we say, you choose what's right for you in your part of the state, whether it's Southern California or Northern California, or coast property versus inland property. It doesn't matter to us. You figure out what's right for your particular area, your particular practice. Choose buyer, choose seller. You notice we have a both column there. And at the very top, I know it's a little bit difficult to see because we've got grayed rows there. But it says if both is checked, the cost to be split equally unless there's another agreement. So you could put both, and you could put 60-40 or 70-30 or 80-20 if you want. But if you just check both, that means both buyer and seller are going to split that cost equally. We thought it was too difficult, given that we started off as a statewide form, to have a default to one practice versus another. There's a few exceptions there. Buyer's going to pay for the lender's title insurance policy no matter where you are. Seller's going to pay for the HOA fees for preparing disclosures, and the buyer's going to pay for an HOA certification fee because that's something that a buyer's lender is going to need and want and require, and it really doesn't help a seller to get that certification fee, although it may help as a practical matter in the transaction.
Okay, so this is one other significant difference between the two regimes. Our contracts provide for a closing date that is determined based on when the buyer's contingencies are satisfied or waived. We don't have a fixed closing date, although it can be. You can prepare our contracts with a fixed closing date, but the template is prepared so that it operates where it is a certain number of days after the buyer's contingencies are satisfied or waived, which means that if you remember what I said earlier, a lot of the contingencies start from when the seller provides a document. Depending on when the seller does that, the end date of the contingencies, they're not all the same date. So we have a floating contingency expiration date. We also have a closing date, which is 30 days after the buyer has satisfied or waived. Now you could put, instead of 30, the default is 30, but you can put in a shorter time frame if you want, so that you have a 15 days after the contingencies are satisfied, or whatever period of time you want. That's a significant structural approach that you should appreciate, because I think it's very different than the CAR approach. Our contract says the closing is going to happen on that date or soon thereafter, as escrow is in a condition to close. And our contract section 8.8 requires a party that's not then in default to give a 5 business day notice and opportunity to cure before the contract is terminated. Neil?
So you can go back to the previous slide because I realized I didn't realize this earlier that I left off a slide. I don't want you, Chris, to go back to slide number 3, but slide number 3 shows the beginning of the purchase. Oh, you did that pretty easy.
Is that where you want me, Neil?
You didn't, no, slide 3. Oh, I'm
Oh,
not
way
sure.
at the very beginning.
Oh, it's not slide 3 for you. That's right, because you have a different. Don't worry about that. Don't worry about that. I'm just going to
Okay.
read to you what the CAR form says about close of escrow. So just go back one slide. We're still talking about close of escrow. You can see the AIR approach. The CAR approach is that there's a fixed time starting from the date of acceptance, right? So Bryan mentioned you figure out a closing date after you get your waiver or expiration of contingencies. With CAR, once you are in agreement, you know when the closing date is supposed to be. And it's either going to be a certain number of days after acceptance of the contract, or there's a choice to write in an actual fixed date. So that is a different approach. Prior to or upon whatever that fixed scheduled close of escrow date is in the CAR contract, before a seller can cancel, the seller has an obligation to give a buyer a demand to close escrow. So a seller cannot, that goes along with our active removal of contingency approach. That approach is similar to canceling for failure to close. Seller, you cannot just cancel if the buyer did not close on the date of the scheduled close of escrow. You first have to give a demand to close escrow, similar to a notice to buyer to perform. And then once that time period has lapsed from the demand to close escrow, then the seller can issue a cancellation if the buyer has still not performed. So that's the difference in approach there. Now you can move on.
Okay, so in the AIR contract, the liquidated damages in section 21, you fill in the amount of the contract and it needs to be separately initialed. The seller gets to keep that money if the buyer goes to approves of all contingencies and fails to close escrow when the closing date comes around. The seller pays the escrow and title fees, but gets to keep the liquidated damages obligation. Our contracts do not have a mediation obligation anywhere. We don't have mediation in the contract at all. The closest thing we have is the arbitration provision in section 22, and that only applies to who gets the earnest money deposit in case there's a dispute. If the contract is terminated by either side, the seller is going to claim, I assume, that the buyer defaulted, and therefore the seller gets that money as liquidated damages, and the buyer is going to contend that the seller defaulted and it wants a refund of its earnest money deposit. That dispute is the only item that's arbitrated, and the commercial rules of the JAMS applies to the arbitration.
Can you give us just a little note on mediation, why it's not included?
We don't need the mediation process because we have significant amount of time built into the contract for the parties to resolve if something comes up about a repair request. And so that's one level. I think sometimes the disputes arise as to what happens during the repair request. The mediation is something that's, first of all, non-binding. I think it maybe delays all the processes of the contract. So I think if there's a dispute before a set, arguably, and I'm not sure, maybe Neil can address this, can a seller terminate the contract without going to the mediation first? And we just wanted to keep it plain and simple. The contract that's signed governs the parties' relationship. You don't need to resort to some kind of a mediation before you terminate. And if the parties want to mediate afterwards, they're all welcome to do so. They don't need us to guide them to that. And I think the CAR has a whole mediation uh, uh, section set up that deals with this mediation. We don't have a similar body to deal with mediation that comes out of AIR disputes.
And yeah, here we see some differences between the forms. So liquidated damages in the CAR contract, by default, it applies to the full deposit amount. Remember, in the AIR contract, a dollar amount needs to be written in. It might be the deposit amount. I don't know if there's a common practice, Brian, but we just default to, okay, liquidated damages applies to the full deposit. If there is going to be an increased deposit during the course of the escrow period, maybe the buyer starts off with something low and the seller wants that amount to be increased, then you need to use a specific form delivery of increased deposit for that additional amount of money to apply. CAR does have a mediation clause. It mandates the parties mediate before they litigate or arbitrate. It defaults to the CAR Dispute Resolution Center, but the parties can mediate at any service or with any mediator that they mutually agree to. When CAR introduced its mediation first requirement into the contract, we were concerned that parties will say, well, it's a non-binding mediation. You can't force parties to try to reach a settlement. So what good is it? So CAR inserted that if you do not mediate first, you lose your right to prevailing parties' attorney's fees, even if you subsequently win in a lawsuit or in arbitration. We found that's been very helpful in getting parties to the table. Most mediation providers have a very good settlement rate, and that's beneficial. And we believe it's also beneficial for real estate licensees because if the buyer and seller can reach an agreement through mediation, there's less likelihood that a broker will be sued by one of the parties to the transaction. The arbitration clause, unlike the AIR clause, it applies to any dispute or claim. So where do most claims occur? Most claims really do not occur before closing or before cancellation. Most claims occur after a closing where, and I think Brian alluded to this earlier, most claims are brought by buyers. They're brought by buyers who are unhappy with some aspect of the transaction, some aspect of the property, some disclosure that they believe the seller did not make that should have been made. So when the arbitration clause is initialed, it can deal with pre-closing or post-closing disputes. Our experience is that most are post-closing disputes. There are some exceptions, for small claims issues, or if the matter is a probate case, for example, we say, if it's already being handled elsewhere, we don't want it to be handled contractually. So hopefully that explains some of the differences in the reasoning.
So the AIR in section 12.1 has a seller making certain representations or warranties, which I would say these are the basic representations and warranties that a buyer who was represented by competent real estate counsel would get from a seller. So we kind of cover the bare minimum. Obviously, as a buyer, you may want to embellish and expand these, and as a seller, you may want to cut these down or negotiate them away. But basically, it says the seller owns the property. The seller has the right, power, and authority to sell the property. The seller is going to keep the property in the same condition. The seller doesn't know of any hazardous materials contamination, doesn't know of any violation of laws. Seller's not going to change any of the leases or other contracts during escrow. And there's nobody else in possession of the property other than the tenants that were disclosed by the seller. There's no mechanic liens on the property. There's no lawsuits. Seller will notify the buyer of any changes that happen during the escrow period. And if the buyer learns of a representation or warranty that the seller had made, which turns out to be untrue, and the buyer still buys the property, then you snooze, you lose. It's a waiver. If you know there was a breach and you close, then you've waived the right to sue the seller for breach of the warranty. If you go to the next slide, please. So the contract requires the seller to provide two documents to the buyer at the very beginning of the transaction, which I referred to them earlier. One is the property information sheet. The other one is the seller's mandatory disclosure statement. The property information sheet is a document that is meant to help the seller go through each aspect of the property and tell the buyer of any known defects. So, for example, it says whether the seller knows of any material physical defects in the property, like the roof. Does all the equipment work? Does the HVAC work? Does the electrical work? Does the property have soil problems? Is the property served by utilities? Was there an insurance claim filed in the last 3 years? Does the seller know of any non compliance of the property with any applicable laws? Does the seller know of any hazardous substance contamination or mold? Was there a fire that happened on the property? And any lawsuits, any governmental proceedings? So this is meant to go through each aspect of the property and have the seller tell the buyer, I don't know of any problems. Now, we combine that, the property information sheet, with what we call the seller's mandatory disclosure statement, which is really a document that is made up of two documents, if you will. The seller's mandatory disclosure statement requires the seller to provide a natural hazard disclosure. As part of the seller's mandatory disclosure, the natural hazard disclosure takes care of making the disclosures that are required by a lot of California statutes as to whether or not the property is located in an earthquake zone, a fire zone, a flood zone, et cetera, et cetera. Then the seller's mandatory disclosure statement goes further to provide an earthquake safety booklet and make the disclosures that are required, whether or not regarding earthquake safety, whether flood disaster insurance is required, are the water heaters braced, if these are legally required disclosures. Is the property near a methamphetamine laboratory activity? Does the seller know of any hazardous substances, contamination? Are the water conserving plumbing fixtures installed? Was there a death on the property in the last 3 years, et cetera? So those are the statutorily required disclosures that a seller is supposed to make. So these two forms take care of providing the buyer with the disclosures that a seller is required by statute and by common law. And that is basically how we deal with those disclosures. Neil?
Yeah, absolutely. Thank you. Next slide, please, Chris. So CAR has our warranty sort of spread out throughout the form. So Bryan was talking about the property information sheet. Nice, one document where you have all of those warranties. The CAR form has warranties sort of built into different paragraphs, 7B, 7D, 5, 9. 11 is a disclosure paragraph, deals with items, as Bryan mentioned, like the natural hazard disclosure. But you see in the middle of paragraph 11, requires the seller to prepare a commercial seller property questionnaire. So those of you who've had a residential transaction, you know that what's required by law is a real estate transfer disclosure statement, or the TDS. And CAR prepared a seller property questionnaire that we created on our own to have the seller provide additional information. That was the SPQ. For a commercial transaction, we created a commercial seller property questionnaire, and that's where the bulk of the disclosures are found. Ask the question the same way that a transfer disclosure statement or the residential seller property questionnaire. Seller, are you aware of? And then there's 4 pages of questions asking for the seller's knowledge concerning the property.
All right, let's go to the next slide, please. So another section that we should discuss is this assignment section. Our contracts give very, very broad and liberal rights to the buyer to assign the contract. It does. Our contract does not require the seller to consent to an assignment of the buyer's rights, and the buyer remains liable under the contract. So if that's unfortunately one of the biggest misconceptions in our industry, when somebody assigns the contract, they think they're off the hook, but they remain liable. And our section 1.1, although it was not necessary, we put it in there to reiterate that just because you assign, you're not off the hook unless the seller expressly releases the buyer. Now, this is the governor for somebody who wants to, for example, they have a widget manufacturing business. Oftentimes, they want to buy a facility, they enter into the contract in the same entity that operates, then they're going to form an LLC at the closing, then take title to the real estate in the name of a single purpose entity that's going to only own that facility. So this gives the buyer the right to transfer the contract to, and it's not just limited to that, it gives the right to the buyer to assign the contract. This is also the governor as to, can the buyer do a flip? Can the buyer do a double escrow? Or can the buyer form a new LLC, bring in new partners, raise money through a private placement, and fund the transaction that way? So our contract gives very, very broad rights to the buyer to assign without requiring the seller's consent.
And you can see from the two CAR paragraphs that are referenced, more limited. So this is a carryover really from the residential purchase agreement, and the language has been carried over to the commercial purchase agreement, that unless the buyer is transferring to their own trust or a wholly owned entity, then the buyer first has to seek the seller's consent to an assignment. The seller has to be reasonable in determining whether they're going to consent or withhold consent. And then CAR has, and you see it there in paragraph 3K, we've stated, buyer, if you're going to be assigning, you've got to make that decision early in the transaction. The default is the same as for our contingencies and contractual actions. The default is 17 days. And then if you make your request for an assignment after that point, the seller has the right to say no because you're beyond the time within which you should have made that a request for assignment. Bryan, I agree with you. We get that misunderstanding all the time where there has been a assignment. Let's say the assignment has been consented to, and the original buyer thinks they're off their hook when legally they are not. I did want to mention in this segment that CAR has an assignment of agreement addendum, which is the agreement of the assignment between the buyer and the assignee, as well as the consent by the seller. So that's a form within the CAR library that could be used. I actually think that's a form that would carry over fairly well even to the AIR form. But again, anytime you mix and match forms, you always want to have a lawyer review them.
Yeah. So our contract has, as part of the due diligence in favor of the buyer, the seller providing the buyer with a estoppel certificate signed by the tenant. This is part of the default contract. You don't need to check a box. The reason for this is obviously in commercial transactions, it's very critical for the buyer to understand what the status of the leases are, make sure that the tenants are all current. What does the actual lease look like? When does it start? When does it end? Were there any subleases? Were the tenant improvement allowances paid, et cetera, et cetera? How much CAMs were collected? Common area maintenance charges collected, et cetera. So this is part of the template, and the seller has 10 days to provide the leases and the estoppel certificate. If the seller can't get the estoppel certificates, then the seller has to give its own estoppel certificate to the buyer, and that's how the buyer gets comfortable. Now, some buyers may decide, no, I don't want to use a seller estoppel certificate. I want to get one from the tenant, because if it turns out that the seller estoppel certificate was wrong, then all I've done is buy myself a lawsuit, which is not what I'm interested in. Neil?
Yeah, thank you, Bryan. So you're right, big difference. The requirement to provide a tenant estoppel certificate built into the body of the AIR form. It's an optional paragraph in the CAR form, similar to AIR. If that box is checked, if the seller is unable to get a tenant signature on a tenant estoppel certificate, then the seller has an obligation to provide that certificate that the seller prepared. So at least the buyer knows this is what the seller believes are still the active terms of the the tenancy.
Okay. So now, uh, our contracts, like I said at the beginning, in response to Chris's question, state exactly how much is each broker going to get paid. The seller in section 27.2 is supposed to pay the brokers their commission. It says who gets what percentage, and that part of the contract is also says that it's escrow instructions so that the escrow company pays the brokers. Um, the other protection that I mentioned was the section 18.1. If a party defaults and the escrow doesn't close, that party has to still pay the brokerage commission. Obviously, this is something that the sellers should and the buyer should be aware. If a buyer backs out of a contract, not only could the buyer owe liquidated damages to the seller, but this buyer could also end up owing the brokerage commission to the brokers. Section 24.2D puts a 1-year statute of limitation on suing the broker for negligence, and it also puts a cap of the fee that the broker received for the broker's liability, except if in case of gross negligence or willful misconduct. And 7.1 says that if the buyer buys the property a year after the buyer makes the offer, then the broker is going to be representing the buyer. This is to make sure that buyer and seller don't get together, collude, and say, okay, let's just wait for a while till the listing expires, and let's just make the deal together without the brokers, and we'll split the commission savings. So this is to protect the brokers that they get paid for the work that they did to bring the parties together.
Yeah, so great. If we go to the next slide, we'll see some of the differences here. And so CAR, again, does not put into the body of the purchase agreement the amount that the seller agreed to pay the seller's agent or the buyer agreed to pay the buyer's agent. What there is, however, in that grid, there's a paragraph, it's 3G3, where the buyer can ask the seller to pay the compensation that the buyer owes their own broker under that separate agreement. If the seller agrees to that in the body of the purchase agreement, that becomes a binding obligation on the part of the seller. And the, excuse me, the buyer's broker is a third party beneficiary of that seller agreement to pay the buyer's broker. So we don't want the buyer trying to shift that responsibility to the seller. The seller says yes, and then the seller doesn't pay. Then the buyer's broker has an uncomfortable decision to make. This way, the buyer's broker can pursue the seller for breach if that happens. The listing agreement, seller and seller's broker agreement, or the buyer representation agreement, buyer and buyer's broker agreement, separately deals with the issues of what happens if the principal does not pay pursuant to their own agreement, and there are rights under those agreements to work things out. If you go back a slide to the AIR form, I want to mention that CAR does not have clauses which I think are great for the brokerage industry, Bryan, that you have there in 24.2 and 7.1. CAR is a statewide forms provider and has always been a statewide forms provider and is the dominant forms provider in the industry, was just worried that if we included a clause like that, courts might say that we were overreaching. So we had a concern. I think it's a great clause. Love that you were able to do it. CIR had some other considerations that we had to take into account, which is why we do not have 24.2D. 7.1, what we do have is in the listing agreement and the buyer representation agreements, we have language in those agreements itself that if you check a box will prevent a buyer and seller from just waiting out the terms of the listing or the buyer rep agreement, because the terms of that agreement can carry over for a period of time that the brokers and the buyer and sellers mutually agree to. So nice that you've got that 1 year automatic exclusivity. We deal with that in the representation agreements.
All right. So here's another significant difference between the two contracts. With the AIR contracts, the user is allowed to actually go into the body of the contract and modify the actual text. You can strike through, you can add, but what it will do, it will color the changes in red.
Mhm.
I get so many calls from people say, I don't want the other side to see how I changed it. Okay, and the whole point of the software is to not permit that, because a lot of our users are familiar with the base contract. They don't bother reading the whole contract after working with them for 10, 20, 30 years because they're fully familiar with what they already say. And one of the reasons they use it is because exactly they don't have to reread it. So by making a change and having that change highlighted, then it makes it easier for somebody who's familiar with the contracts to use the contracts to see, oh, what was changed? I know what the base form says. Let me look at what was changed. Now, a lot of people make changes in the body of the contract. They also use an addendum for more extensive changes. So our contracts also publish an addendum that you're free to use to make if more changes to the contract if you don't want to make the change in the body. Neil?
Yeah, great. So CAR, again, using the member benefit program, which is zip form, does not allow changes in the CAR form itself. So that's not just the residential purchase agreement, the commercial purchase agreement, or any of the other in the large library of CAR forms. Changes need to be made by addendum. But if you are using the AIR library that you could separately purchase as a separate library through zip form, then you are allowed to make the same strike throughs and changes that you are permitted to if you go direct to the AIR library. I have to tell you, Bryan, I was I was unfamiliar with the fact that the changes show up in red. I really like that. That was there was some concerns that CAR members had for making changes. One was that, how would it be identifiable? And you solve that by having the change be in red. CAR had other concerns, which were brokers and risk managers really did not want licensees to be making changes on their own, and they were concerned about what would happen in that respect, regardless of whether it was easily identifiable. But I love the fact that you've got a colored coded change in your strike throughs.
Thank you. And I think that's it, right, Neil?
That's all that we have prepared, Chris. So probably closing remarks from you.
You know, this has been fantastic. And I think that you guys are doing better as you're working together over the years because I think this presentation was much better than the one I heard in March of 2019. But I really appreciate you guys. I'm quickly putting your bios up here on the screen so someone who's watching this can go back and take a look at it. And I'm very excited to have had you guys on today. Looking forward to maybe opportunities in the future to interact with you guys and maybe do some additional commercial real estate training. So if you have some ideas that you'd like to explore with us, we'd be very happy to hear about that. Do you have anything else that you'd like to say in closing?
Just first of all, thank you for the opportunity. I'm glad to hear that we've got better over the years. I would have been
Yeah.
disappointed if we got worse over the years. And the members of the Realtor Commercial Alliance, as you say, they have access to this information. It's been recorded. And if they have questions, I know they can use that email address and contact me if they would like to.
Yeah, and this is actually on YouTube. So, if people are calling you up and asking you questions, you say, hey, we did this great video. It's on YouTube. So be sure and share that with your clients and people who call in and ask questions also. All right. Well,
Thank you
with
so
that,
much, Chris. Thank you very much.
thank you, gentlemen. And thank you, everyone, for joining us and staying to the end of the video. And we'll look forward to seeing you on our next live event. Be sure to go to rcaoc.org and sign up for the mailing list if you haven't already. All right, guys, have a wonderful conclusion to your summer.
Thank you.
Thank you.